It was the respondent in this context published an article stating that given Lubinga is not a strong standing political candidate, as he dishes from this candidate or from this political party to another, only the consideration that he may end up being given a ministerial position. So in this context, my Lord, as I was trying to submit, I will wish to go further with my submission.
My Lord and my Lord.
Pass over seat.
It's actually time out, so just say a prayer.
Much obliged, my lady. It is our contention that this court will find merit in our submissions and will quash the decision that has been, will render the decision of the lower court as void, and by upholding our appeal.
Squash it. Just squash it.
Like making it non-applicable, such that we are not required to pay whatever the remedy has been. Much obliged, my lady. It is our prayer that this court will find meaning and merit to our submissions. We submit.
As already stipulated in the report, my name is Actress Brenda Chibika. I'll be arguing the second round. If I may refer the court to section 7 of the Defamation Act.
You're arguing the second ground. What ground is it?
The ground. The lower court erred in law and fact when it rejected the defense of their opponent. Much obliged. If counsel may refer, if you may permit counsel to proceed. As I read section 7 of the Defamation Act. In an action for libel or slander, in respect of words consisting partly of allegations of fact and partly of expressions of opinion, a defense of fair comment shall not fail. So when we read that part, this part aligns with the position established in the case of Bevan versus Post Newspapers Limited and another.
What year was this case? What's the full citation?
The full citation is
What's the case?
Council 16 consult. The case was cited in the case of charity. So the notion in this case is that it established the three requisites of defense of the opponent, of which the first is the comment must be an observation of reference. Much obliged.
We're actually ready to prove. We want you to argue this. So we don't expect you to look at the proof.
Much obliged. In that note, this case, in regards to Section 7 of the Defamation Act, we see that the first point that was established in reference to facts not an assent to the comment must be an observation of reference from the facts and not an assertion of facts. That is evident because when we read paragraph 8 line 7 and paragraph 8 line 2 of the facts respectively, having the captions law enforcer involved in a punch up with subordinate assistant superintendent, and the caption it is an expression of, and the caption law enforcer involved in a
We're not following through. Well, we can't.
We are on the first comment established.
Yes, we know where you are because we can read with you.
Much obliged.
So we want you to argue your case because I can read here. Paragraph 8, line 7.
Yes. So looking at the notion of the facts established in the case of Bevin in section 7, we established that the two captions that were publicized by Outline were allegations and an opinion. Then we go to the second notion, which is established in this case, which is public interest. And if we look at the facts of the case, we see that Miss Patel herself, in her own words, when referring our reporter to the public administrator, said the event took place in a public place. So this event was a public domain, and by virtue of Miss
What is
Patel,
public domain?
of public interest. I mean, much obliged.
So you say fair comment justification in case you can say it must be based on truth and fact, on opinion and fact, isn't it? And that opinion must be true in order for us to say it's fair comment, right? Now going back to the facts, do you think it is true that she did get into that fight?
Looking at the facts, my lord, we see that the reporter made was reasonable enough to
Before the
concern.
report, did she engage in the fight according to the facts?
But as per the facts, she did.
She did.
Yes, and
When she was waiting outside the door. Because the fact said, the lady named Nancy was waiting outside the door. And Miss Nancy just heard somebody crying outside. And when people came to check, they found her crying outside of Miss Nancy's door. Do you agree with that?
Yes, much obliged, my lord. In that aspect, we look at the facts to say Miss Patel, we question Miss Patel's statement. Because in the facts, we know to say that Miss Patel says she has a good relationship with others. But however, in the same facts, we know to say that she is unapproachable. Bringing us to the question of how can a person be unapproachable and have a good relationship with others?
Did they engage in the punch-up?
In the budget, that's an allegation, making it a fair comment.
Did she enter Miss Patel's office?
No, she did not. She was
Did not.
not.
How do you find someone when you have a test?
As much obliged, my lord. As per the facts, we know to say James, the friend to the reporter, where the reporter got his information from, said that once he heard the blow outside the noise, he rushed, and once he got there, he saw Miss Patel entering her office and Jane leaving there crying.
And why did Miss Patel leave her office? What was she going to do? To punch somebody?
In that notion, since it's an allegation, we can allude to that.
The fact says it's an allegation that she
No,
left.
as per the defense of their form of knowledge.
No, not the defense. The facts as they are. Before we even come to the journalist, it is stated that she heard something outside.
Yes.
And after that, she even refused to say, no, didn't actually.
Yes, because
But based on someone who saw that, oh, that one is leaving, is entering our office, and that one is going outside, most likely will find him.
yes, because
Wouldn't you say that was malice? What if the accountant had malice? Because they didn't like her. Do you agree that they didn't like her?
they did. She had the notion to say they did like.
She had the notion. Would you justify that notion based on what she was called to? Regardless, was she a bad person according to you?
Much obliged, my lord. As per the facts, we know to say that she was given say nicknames, Commando, Mama, G-Star, and every day. So in those, for a person to receive those nicknames can be the nicknames in question can be baseless to say because it's just like a nickname.
Do they agree? Do they assert good character or bad character?
They accept bad character, however, they are mere nicknames.
The male.
Yes.
So if Commando is in a punch again, then something must happen. She must have done it before, and she's doing it again. So are you assuming she didn't do it? Did it before?
Council 16 for something. My lord, looking at the nicknames, I would like to extract my earlier statement when I alluded to say the nicknames that were baseless. In the sense that these nicknames have ground and have merit. Ground and merit to say if she was referred to as Commando because a nickname comes from somewhere.
Bad character.
Yes.
I think we agreed that she did have that.
Yes. Much merit.
Proceed to your point.
So my prayer is that this court proves to say that there was no defamation as the defense of fair comment enabled to the point that my prayer is that this court proves that there was no defamation in my client Times 370 television did not commit any form of defamation because this was an allegation and an opinion in which public officers are open to criticism. Their officers are criticized.
So as alluded by my state counsel, that I'll be arguing the third round of appeal, which is the trial of judges error in law and in fact when it awarded compensatory damages and aggravated damages on a defamatory statement which was not proved. My lady, my lord, defamation we can clearly see as it was stated by my earlier counsel to say it tends to lower the plaintiff's reputation in society. But looking at the fact that their client, the appellant, and the respondents, and when we talk about the respondent was a public official. Therefore, a public official is open to criticism, as seen in the case of New York Times Company versus Sullivan, 360.
So you agree that the statement was defamatory, but it's justified because they are open to criticism?
Much obliged, my lord. I seek leave to defend. Yes, counsel.
Is the statement defamatory?
The statement is not defamatory.
It's true. It's true that she engaged in a fight.
The allegations can be true.
Is it true that she actually engaged in a fight?
Yes, she did. Much obliged, my lord.
Because of that, it's not defamatory because she's still a public figure.
Yes, my lord. I would like to bring to the attention the case of New York Times Company versus Sullivan.
This case isn't it a USA case?
Much obliged, my lady. It is a US case, but it has been used for its persuasive reasons, as it was also cited in the case of Michael Santa versus the Post.
Then why didn't you write Michael Sutton versus the Post? Isn't it that when we don't have our laws here, then we can use the persuasive one? Why have you cited a
Much
United
obliged, my
States
lady.
case?
Looking at the fact that this is the founding case and it was backed up in our jurisdiction by the Michael Santa case, so we have to make reference to the founding case and bring the one which is backing up, which is the Zambia case.
But I haven't seen this Michael Sutton case here.
Much obliged, my lady. Council seeks leave to amend.
So we expound it from your record.
Council seeks leave to consult.
What are you consulting about? To remove?
Council seeks leave to consult. Much obliged, my lady. pray that it's not excluded from the records, but we pray that it should be. It was an error on our part. It should not be excluded from the records.
If it's an error, then it should be removed, isn't it?
Not including an error, not including the microsite. Yes.
So you say defamation is what tends to lower the estimation of the client before a reasonable class, society in general. Do you think the statements that were made, the two statements, did they tend to lower the estimation of Nancy? The estimation of right-thinking members of society? Did it?
Much obliged, my lord. Looking at the facts in carefully, we find that the plaintiff or the respondent, the reputation was not lowered, neither did they, even in the right-thinking members of society, because she was actually transferred on the same capacity, another division, which came 6 months.
Would you agree that she would not have been transferred had that scaffolding occurred?
Much obliged, my lord. I would disagree on that part.
She was just transferred.
She was transferred on administrative basis.
On administrative basis. But it says she was then transferred. After the fact, she was then transferred. Contextually, you would only interpret it to say it's because of this that happened, isn't it?
Much obliged.
Would you say her estimation in society lowered?
Much obliged, my lord. Her estimation in society was not lowered.
Then what did people ask? People would enter her office and say, why do they call me this? People knew when she was called Commando, the silencer, Mama G. And they would come and ask and say, look, people are calling you this. Why are they calling you? So if after asking her that and she defends herself and says, no, it's not true, it's because they just don't like me. And later on they hear it in the news that, oh, the lawmaker has now become a lawbreaker. Don't you think they would think she's lying? She lied, that those people were not true? Because why is she fighting with the person anyway? Reasonably, you would think she was lying to say that she's just not this.
Much obliged, my lord. When we look at the statement, it said, Commando it again. In Zambia, we have multiple commandos.
Let's work with lawmaker becomes a lawbreaker. There are two statements that were made.
A lawmaker becomes a lawbreaker. And looking at the facts that we have, she was a police commissioner, and a police commissioner is a law enforcer and not a lawbreaker, and not a lawmaker.
Let's consider layman's language. This is a lawyer.
A lawyer.
Let's leave it at lawyer. So clearly, before you came to law, you thought the police. So did I, because that's what we see, isn't it? And now you know better. Speak as a lawyer, as a layman. So let's leave it at lawmaker. Do you think that would tend to lawyer? The person who had come and made reasonable inquiry, are those words true? Later on, they just hear you engaged in facts. Would that tend to lower your estimation in their capacity? Yes or no?
Much obliged, my lord. No, it does not tend to lower, because lawmaker can actually refer to anyone who makes law. As we all not say, Parliament makes law.
It's command. Just referred to command. And people were asking because they knew she was called. So we know who we're talking about.
Much obliged, my lord. When people refer to you in a certain way, on a particular area or society, it won't be news to them when they find to say this person is like that, because people from her workplace are the only ones who would have understood that, and they would say that's how she is.
And why do people come and ask, is it true that you are actually a silencer? That you say this and you're a very manifolding person? Why did they ask if only the people in the workplace knew about it?
Much obliged, my lord. People who were actually asking were people who come from outside and not the people who.
So would it tend to lower her her image, their capacity. They think, oh, maybe she was just even lying that they don't like her. Because why would she fight?
Much obliged, my lord. As the article was published, my lord, it's clearly stated, commando at it again, from a lawmaker to a lawbreaker. Basically, those people who used to come to the office who would have understood to say, to refer to her because there are a lot of commandos and we have a lot of members of parliament who make way.
So, was it an innuendo? Commando, Mama G would refer to anybody.
Much obliged.
Does a person have a right to sue? They have capacity. When Njolo is saying you need to have capacity to be able to sue, isn't it? If she thinks, does she know that Mama G refers to her? Does a reasonable class of society know that Mama G refers to her?
A reasonable class of society.
Both people in her workplace and outside of her workplace, considering those who would come to her coming from outside, did they know that those words have a connotation to her and the way she behaves through it?
People knew, much obliged, my lord, people knew that she was called Mama G. But when we look at the news article, it says Commando and Mama G was not in the article.
People knew Commando, Mama G, and the silence, all three.
Yes. When the article was published, my lord, it stated Commando at it again. It didn't specify to say Mama G, neither did they specify to say silencer. Thus, it doesn't apply as the class of society wouldn't have known to say it referred to this person because we have a lot of commandos inside.
And silencers and Mama G.
Silencer and Mama G was not shown in the article, as the article clearly stated to say, as the facts show us, say it stated commando at it again, from lawmaker to a lawbreaker, and Mama G and silencer was not in the article. As I earlier alluded, say, in the case of New York, if a plaintiff in a defamation lawsuit is a public official, then not only, much obliged, my lord. My lordship, it is my humble request made to this honorable court to set aside the compensatory damages and aggravated damages awarded by the lower limit trial of judges, and to set aside the full exemplary damages, and to set aside the
want the damages to be set aside. You do not argue. You do not argue that. Why bring it to the prayer?
My lordship, the ground of appeal that I'm appealing, the trial of judges erred in law and in fact when they awarded compensatory and exemplary damages when there was no defamation that was proved. So by this, my lordship, by me stating this as the ground and citing the case of New York and the case of Kasoka versus Times of Zambia, it clearly says that when awarding exemplary damages, the plaintiff must prove actual malice if the plaintiff is a public official. But in this case, the public official didn't prove actual malice. Therefore, we pray that this honorable court.
She asserted that. She said it. What you're doing is you're sidelining everything she said. You're sidelining the fact that you say they do it because they don't like me, because I've held this position, and for 20 years nobody else has held it, and they just don't like me. You're sidelining the fact that the facts before the scuffle even happened are saying clearly that she did not even engage in any of it. She just heard the woman crying. and based on the hearsay evidence of an accountant, because other inquiries were futile, a newspaper article was published. Wouldn't you think there is a very, very, very cogent need to allude to malice here?
Much obliged, my lord. When we look at the facts, we hear that our client actually took the steps and measures to verify the information before it was actually
All
published.
journalists
All
working with opinions of people as to what happened. Is it fact? Tell me one fact that happened. Because you say fair comment is both an opinion and a fact. Tell me one fact that actually happened. The act, the fact, did it happen? Clearly, we are able to see the accountant. That's an opinion, right? Because of what I've seen her entering the office, I think they actually fought. What is the fact? Did they actually fight?
much obliged, my lord. Looking at the facts which were presented by the court, we would also argue to say the allegations of people having malice, talking all of those in malice, were just allegations and her own opinion, if we were to take that route. Therefore, that's why, as the appellants, we pray that this honorable court set aside the compensatory and exemplary damages and set aside the full judgment which was given by the lower court. We submit.
Much obliged to my lady and my lord. As earlier stated, my name is Kambo Tungu, and I'll be arguing the case.
Comfort room. What does your brief say, Mr. Comfort Tips?
It was an error that was made, and council seeks to amend.
You agree with this?
Any objections?
You're
You
fine.
stand and you sit what you stand.
You're fine with just that.
We are fine with council making a decision.
So,
We are fine with
Mr. Tilsi.
Much obliged, Your Lordship. I would like to refer this honorable court to the ascension that was made by the appellant, stating that the statement was indeed the justification was that the statement wasn't defamation, wasn't defamatory. That was the appeal that has been tendered before this honorable court. Furthermore, I would like to draw this honorable house to the case of Francis, to the case of Muingu versus Times newspaper, where the Supreme Court held
What
that
year was it?
it is a 1989 case held in the Supreme Court.
Supreme Court of
Zambia. Much obliged. My lady and my lords, in this case, it was stated that it is upon the trial court as a trier of both facts and law to establish whether the statement that was made was indeed defamatory as a matter of law, and if indeed a reasonable person can construe that it referred to the plaintiff in this regard, Ms. Patel. My lord and my lady, I would like to proceed in the following affirmation. It is evident that the case imposes an obligation on the judge to establish these two principles, making sure that the case at hand, as a matter of law, refers to the plaintiff, and as a matter of fact, if a reasonable person can construe that indeed the ascension was referring to
The appearance is saying it doesn't. I'm saying it doesn't because anybody can be a commando.
my lord, we refer to the case of Morgan versus Oldman, where it was stated that for us to construe whether a statement is referring to the appellant, we must make sure that we employ the reasonable man's test, which is the acquaintance of the claimant. In this regard, we will construe that a reasonable person who is acquainted with Ms. Patel will be able to infer that the statement is referring to her.
She's
the statement being a commando in its sense, we understand the fact as the respondent that we have a lot of commandos that are there. But in this state, the court, even if there is no evidence that is tendered before it, will someone who is close or who is within the proximity of Miss Patel infer that they are referring to her? Thus, we established that there was clearly indication that the statement was referring to the respondent.
So defamation is no longer based on the perception of society in general, but personal acquaintance with the person.
Much of that, your Lordship Council seeks that you rephrase the question again.
Defamation is now based on personal acquaintance and not a general perception of whether the words are defamatory.
Council seeks to withdraw the statement that was made regarding personal acquaintance. Defamation, for it to suffice, regarding the issue of reference to the plaintiff, it was stated in the case of Hatton versus Jones, which is an English case, that if it is in the public domain, if a reasonable person can infer that there was reference to the plaintiff, then defamation will suffice. If it is in the public domain and a reasonable person can infer that there was reference that was made to the claimant, or rather the respondent in this case, then it will be established that defamation.
So that brings us back to the question. Would any reasonable person think commando just refers specifically to the sentence of the jail?
Much of that, your Lordship, we agree to the fact that the word commando doesn't differ to any reasonable person, but in this sense, there is a statement which has been added at an introductory of the very publication, which is law enforcer now involved in law enforcer, now lawbreaker, commando, if you know. Thus, a person who is acquainted or a person who knows Miss Patel will be able to infer that the statement was referring to her.
What does it say if you know what I mean? Would any person know what you mean generally? Because the statement says, if you know it, does that refer to a particular class of people who know what you mean? Or it refers to anybody who would just say, oh yes, I. Would any reasonable person out there in society know what it meant?
My Lord, I would like to draw the attention of this court to the last element of defamation, which is publication, as expounded in the case of Sata. This is Post newspaper, where it was stated that for defamation to suffice, there must be the reference to another person, or it must be published to another individual. In this case, we are not, for us to ascertain what we have at hand, we must make sure that we acquaint ourselves with the fact that the statement itself was published to other individuals.
And would other individuals think or understand what, if you know what that means?
My Lord, in this regard, the word other individual, they would automatically infer that the reference is being made to Miss Patel based off the name which has been used to her. Commando. If we see in paragraph 2 of the records of proceedings in the lower court, we will realize that the word commando was used when they are referring to her, and of course, we are aware of the fact that certain names that are used to refer to an individual, they may be used even to refer to her, even if the person isn't at the workplace.
So the word commando is about to make anybody. And if you know what it means, only refers to people who have acquaintance with this, isn't it? So let's get back to an objective test. Any reasonable person who would see the statement understand what it means.
Much obliged, your Lordship. In this case, the word commando itself is very general, and it cannot be inferred by anyone to say that no, the reference is being made to Miss Patel.
So not everyone. Not any reasonable person in society would think that this refers to her, right?
Much obliged, your Lordship, yes. In this sense, what is making the word commando to be known that it is referring to Miss Patel is what has been stated at the introductory statement, and of course what has been added to the word commando. The first thing that has been added is law enforcer, now lawbreaker. Commando at it, if you know what I mean. So someone who is acquainted with Miss Patel will be able to know that no, the reference was being made to Miss Patel.
We're not talking about personal acquaintance. Say that doesn't apply. We're talking about society. Any reasonable person is what you say. Would they think that lawbreaker from lawmaker, if you you know what it means, commando, just specifically means Miss Patel. They would think they're Mongol and they say Stephen and say, oh, that's Miss Patel.
Much obliged, Your Lordship. I would like to refer to the case of E. Atom versus Jones, where it was stated that where a statement has been published and it does not directly refer to the plaintiff, but it is within the public domain, and the person can infer that the message or the defamatory statement
Counsel,
was
you have to fast. Take your time.
much obliged, Your
It's not
Lordship.
a contest.
Much obliged, Your Lordship.
And when you are citing foreign decision, we are Zambian jurisdiction and we have our laws. If you are citing that, that means you have found our laws to be inadequate.
Not
In that
necessarily,
particular
Your
area,
Lordship.
or you haven't found any authority. So before you cite a foreign decision, you seek leave to say it. We are a Zambian jurisdiction, Zambian court. We use what's Zambian. Address your mind to that next. Please proceed.
Thank you very much. Much obliged, Your Lordship. The case that I cited was for perversive values, Your Lordship. Thus, we are of the view that the lower court was on firm ground to grant the relief sought, because it was overwhelming the fact that the statement referred to the respondent in question.
Counsel, all the cases in your brief have no A.
We have cited the A's on the last page of our skeleton argument.
You just cite them as you are writing. To give you the authority to cite them only at the end.
Your Lordship, counsel seeks to amend. Go on.
Before you came here, you were sure before you submitted this. Yes, I am proud of this. If I had to do it again, I would do the same thing. How many times did you amend? Oh my.
It is
Doesn't that just show lack of competence?
it is at the discretion of the court to award us the amendment, the amendment leave.
And when it is too much, the matter becomes very vexatious. It can be thrown out because of such undutiful practices.
We won't grant you leave. We will consider this as being incompetent. Continue.
Counsel would like to proceed to the prayer.
Sure.
My lord and my lady, the court was on firm ground to render its decision, and we now stage this honorable court to uphold the decision of the trial court.
Much obliged, my lordship. Much obliged, my lordship. As earlier introduced on, Nankamba Mwila, I stand to argue grounds 2. If it pleases this honorable court, I would just like to read through, and it reads: the trial judge thoroughly examines the evidence and correctly concluded that the plaintiff's reputation was damaged in the eyes of the right-thinking members of society. This finding was based on solid legal grounds. My lordship and your lordship, allow me to refer this court to paragraph 8 of the record of proceedings, in which the term law... Much obliged. Paragraph 8 of the record of proceedings,
Sure, continue.
where it states, law enforcer involved in a punch-up with subordinate assistant superintendent, commando at it again. Your lordship and my lordship, the learned authors of Summoned on the Law of Torts, 12th edition, states that defamation is a false statement, suggestion, or fact, or the prejudice of a man's reputation. Your lordship and my lordship, from the statement that has been given, and according to and in relation to the case in Kasu, it shows to say at break time, Ms. Patel was accosted by Muyaba, who is the appellant's witness 1, and was questioned of the alleged fight. And she denied being involved, and and as such can be construed that the appellant had a malicious intent in publishing this article. Your lordship and my lordship...
What is malice, counsel?
Much obliged, my lordship. My lordship, malice is an intent. Malice is a bad intent towards certain actions.
So, this answer to say that these people just don't like, and these are false allegations, isn't it? That is what you say. And everyone else but her say because of her strictness and her kind of character, her malvolence, she is then attributed the names of Commando and Mamji and Silencer. Would a person just call you that out of nothing?
Much obliged, my lordship. According to in relation to the facts in the case in Castle, Miss Patel, in paragraph 2 in paragraph 2 of the facts in Castle, Miss Patel did admit to say she was called such names because she was not liked, as she had been the first woman to hold such a position in a period of 20 years. She had already stated.
Our opinion is that it's because of this. But everyone was saying because she's strict and a very malevolent person, a very offensive person, so to say. That is true, isn't it?
We can't construe it to be true as no evidence of that.
I'd say it is true. Isn't the fact evidence enough that it is true?
Much obliged, my lords. There's still no evidence that adjusts to prove the facts.
Then what evidence was there? Since you can say it's not true, neither can you say it's true, then how come you come up with the assertion that it is defamatory? If we don't know, because we don't have any facts, whether it's true, whether it is not true.
I'm much obliged, your lordship. Allow me to refer this court to the case of Zambia Publishing Company Limited versus Elias Amwanza of 1979, in which the Supreme Court had this to say: injury of reputation and natural hurt to feelings need not to be pleaded or proved. My lords and ladies, from the record of proceedings in paragraph 8, as the question has earlier come forth, your lordship, her injury of reputation need not to be proved beyond reasonable doubt, but on a balance of probability. Law enforcer, now lawbreaker at it again, has already reduced her reputation in the right-thinking members of society, seeing that she's holding such a prestigious position and that she was female in this particular instance. Your lordship, Council 6.
That is our opinion. The question is, what is the fact? Isn't it a fact that she was strict? Do you agree that she was strict?
Much obliged, my lord, yes.
You agree that she was strict? That means the second word also agrees. The fact that she was malevolent is so you agree that she was called those names because of those two aspects. Is that justified?
Much obliged, my lord. I will agree to say she was called those names because she was strict.
Because she was strict, but not malevolent.
Much obliged, my lords. I agree.
You agree that she was also called Commando Silencer because she was malevolent.
Yes.
Then how is that spite? How is that malice? If they are giving their opinion that, oh, because of the way she treats us at work, we are alluding.
Much obliged, my lords. I would like to refer this court again to the learned authors of sermon, and they say defamation is a false statement or suggestion of facts to the prejudice of a man's reputation. According to the facts in relation to the case in Castle, Mr. Miyaba had gone to Miss Patel to consult and get what the facts were. And he was told because Miss Patel had denied being involved in this fight. But even after getting these facts, he still went ahead and published an article with such information that he had acquired. Hence, we're constrained to say he had a malicious intent because he had gotten the correct facts and still went ahead and published false facts.
So he got the correct facts. You agreed that the facts are correct. Then how is it defamation if it is true?
Much obliged, my lord. I agree to say he had the right facts at the back of his mind, but still went ahead.
Now at the back of his mind.
He still went, much obliged, my lord. He still went ahead to publish false facts. Much obliged, my lord. I agree to say.
Why is it stated at the back of his mind? This is exactly what happened. You agree that he was right, though, Upon his inquiry, do you agree that he was right in what he found out?
No, Your Lordship.
You changed your mind.
No, Your Lordship. My
Then which
Lordship
facts
and
did you
Your
have
Lordship.
at the back of his mind? Would you kindly explain that to us?
Much obliged, Your Lordship. Mr. Miala had gone to Miss Patel to question her what had conspired, and he got the facts from Miss Patel as they were. Miss Patel informed him to say this is not what had happened. This and this is what had happened according to paragraph 8 of the facts in Castle. But despite being told of the fact, despite Miss Patel denying having been involved in such a fight, he still went ahead to publish the false facts, which were now defamatory, stating law enforcer, now lawbreaker, commando at it again.
Balance of probabilities requires heeding natural justice, isn't it? The fact that other sides must be heard. So she gave her side of the story. Right afterwards, he went on to try and confirm the facts. He followed up the person she was told to follow, isn't it? And he got no response. Wouldn't that be a problem? Not only that, but he goes ahead to the accountants and say, what really happened? So you have two conflicting stories, and the whole population of our workplace who think that, yes, this woman is actually manipulative and would actually do this. So you choose to get her testimony in spite of everyone else's. The general perception, you ignore that, choose her testimony in spite of the journalist's reason for inquiry.
Much obliged, my lord. Mr. Miyawa didn't get any information from elsewhere as his calls were unanswered and no response was given.
The accountant is nowhere.
And much obliged, my lord. And it is because of these facts that he only had one set of facts before him, and those were the facts.
It's just how we do.
Much obliged, my lord. It would have been fair had Mr. Miyawa published the article according to the information that he had gotten from Miss Patel, because those were the only facts that he got. But he chose to set aside the confession of Miss Patel and went ahead with with a malicious intent to publish the article stating law enforcer, now lawbreaker, commando at it.
What do you mean confession? What's a confession? What is your confession?
Much obliged, my lord. Miss Patel confessed to what had happened, confessed to say she did not get involved in the fight.
It's a confession.
Much obliged.
As far as I'm concerned, you only confess something when you're wrong. How do you confess when you're right? I confess that I did actually not do it.
Much obliged, my lord. Counsel 6 to withdraw the statement. Much obliged, your lordship and my lordship. Allow me to refer this court to the case of much obliged, your lordship. Having endeavored to prove to this honorable court that the lower court was on firm ground when it held that the statement were defamatory to the plaintiff, it is our prayer that this court upholds the lower court's verdict. Counsel 6.
Much obliged, my lady and my lord. Standing before the court is Counsel Richard Silla, arguing ground 3. Counsel 6 to proceed.
What is your ground again?
Ground 3.
Yes, spit it out.
It's talking about fair comment.
Much obliged.
Much obliged, it is considering fair comment.
What about fair comment? I take it like we first did. You want to explain to us what fair comment is. To brief down, what is fair comment?
Fair comment, this is an action for libel or slander, and it is considered for
Fair
allegations.
comment is an action
Yes.
for libel or slander,
Yes.
not a defense.
Much obliged, it is a defense.
Speak up, speak up.
Much obliged, it is a defense.
Then why are you saying it's an action?
I use the definition from the Defamation Act, my lady. You may proceed.
Proceed.
Uh,
It is on fair comment. I hear the name.
it is a defense of libel or slander in the respect of words consisting of partly of allegations or facts and partly of expressions of opinion. A defense, a fair comment shall not be failed by reason, only that the truth of every allegation or fact is not proved if the expression of opinion is of fair comment, having regarded to such the facts alleged from the Defamation Act.
Did you seek leave to read from there? Proceed with your arguments.
Much obliged. My lady and my lord, we the respondents submit to the trial court correctly dismissed the defense of fair comment, as the publication was not based on true and verified facts. Section 7 of the Defamation Act, in this case, the appellant failed to establish that the alleged alteration actually took place before the publishing of the defamatory statement. My lady and my lord, we refer this honorable court to paragraph 2 of the facts, which shows that the appellant's journalist, Muyaba, sought clarification from Ms. Patel, who categorically refused. Much obliged. Let me see.
Are you the one taking up ground floor as well?
Much obliged, my lord.
Somebody has to repeat himself.
Due to unforeseen circumstances, the one who's supposed to take up ground floor is in Prague.
So you will take it up.
It has been a.
You will take it up. So you're the lead counsel, you're going to be the facts of the case. Let her finish. That's fine.
No.
We agree. Also, if you object, you will score points.
What do you want to say?
Don't worry.
The statement, we consulted the organizers and they said that it has to be extracted since the person.
Then why did you seek leave from the beginning of the court session? Expound it from the records, because I'm expecting someone to argue it, and it's going to be you.
Most of that, your counsel concedes to having made a mistake.
Are you going to argue?
Nothing.
So it's fine. You can consider your marks regarding this. Because you do not say. That's fine.
Counsel wishes to consult.
What's there to consult? You're the lead counsel. It's either you argue it or we consider your marks for it.
Consult.
Quickly, counsel, we're running out.
Counsel has agreed that the fourth round will be argued by the lead counsel.
Much obliged. As we refer this honorable court to paragraph 2 of the facts, which shows that the appellant's journalist, Muyaba, sought clarification from Ms. Patel, who categorically denied the allegations and directed him to check with the provincial administration. Instead of relying on this official denial, the journalist ended up publishing a verified witness account. This lack of due diligence negates good faith and requirement under Section 7 of the Defamation Act. My lady and my lord, in the case of Charity Katanga, the court held that media reports on public figures must be based on facts and reasonable inquiry, and that supports our position.
Counsel, do you think there was reason for inquiry?
Much obliged, there was no reason.
If I ask you and you have refused it, and you tell me to follow her, and she refuses, then I go to someone in your workplace who has personal acquaintance with you, according to what you say. Would you consider that to be reasonable inquiry or enforcement? And if so, how is it enforcement? Do you think that the journalist made reasonable inquiry when she asked and she was referred, and when she made reference she was not answered, and she asked the person who was personal acquaintance, and he gave his view? Is that reasonable acquaintance or it falls short? And if it does, then how does it fall short?
Reasonable inquiry was not present, fell short of it because Ms. Patel did not respond, and the person she had referred the journalist to did not respond to the phone call, which meant there was no reference that was given for the journalist to go on and publish the report.
Doesn't that just prove that she actually did it, but she just didn't want to go ahead with talking about it? And she was just trying
obliged. No, it does not.
It does not make an influence, but there's a possibility that it does make an influence, that she was blocked because she didn't want to talk about it because she actually did it. Wouldn't it?
No, it doesn't.
Yes. That's the way it is.
Much obliged. Yes, it does.
Okay. So this is a public figure. You agree?
Yes, my lord.
Public interest. Do you have the right, you, let's say the journalists, the media, the press, do they have the freedom to criticize public figures?
Yes, they do.
Is that defamation? Do you think this lady was criticized? And somehow it's defamation?
Our bank in fact is up the case of Mwanza versus Zambia publishers. In that, the court held that imputations in Mwanza versus Zambia publishers, the court held that imputations suggesting inefficiency and unsuitability in one's professional role are defamatory.
When you say that you engage in the fight, does that mean you're not able to do your work?
She is able to do her work.
So that is a if you're able to criticize that, in this case it was done based on an inquiry, albeit it's a defamation, but criticize the person based on the information available to me and I'm told by reasonable class of society. Is that defamation?
Council seeks to proceed. My lady and my lord, in this honorable court,
In summary, what are you trying to do?
I'm trying to convince you that
Much obliged.
much obliged. I'm trying to convince you that under fair comment, Miss Patel was allegedly defamed with the statement that was published by the Times.
Not a rap contest.
Yeah, not a rap contest.
Okay, so calm down. Calm down and tell us what you're trying to do. In summary, what are you trying to say?
Much obliged. In summary, my argument is based on the lack of factual basis, reckless reporting, and malice leading to the correct dismissal of fair comment defense.
What is your premise?
Much obliged. Having endeavored to prove to this honorable court that the lower court was on firm ground when it held that the statement were defamatory to the plaintiff, it is our prayer that this court upholds the lower court's decision.
Because each time you get into a discovery, each of the marks that increase your marks based on your argumentative purpose.
Just summarize it. 2 minutes. I won't distract you.
Much obliged. We are of the view that the damages that were granted, which is compensatory damages and exemplary damages, aren't excessive, and thus we seek that this court reaffirms the decision of the trial court. My lord and my lady, I seek leave to take the attention of this honorable court to the learned Arthur in Phillips and Lewis.
Sorry, you say they are not meant to be excessive.
The contention of the appellant is that the damages were excessive. The 20,000 which was granted as exemplary damages, and of course the 35,000 which was granted as compensatory damages.
I was saying they are not.
Thus, we are of the view that they are not excessive.
I should believe you have acquaintance with what is meant by exemplary damages, isn't it? They are intentionally made excessive to show yourself. You are still of the view they are not supposed to be excessive. They have to be compensatory in nature.
Much obliged, Your Lordship. We are of the view that the damages were not excessive. Our appellants brought forth before this honorable court.
What is your interpretation of excessive?
The interpretation of excessive. Excessive in its literal sense, it means something which is abnormal or something which mustn't be granted, it is excessive.
And what is the aim of punitive or exemplary damage?
The aim of punitive damages is to make sure that it deters other individuals from continuing with the same vice.
There's a need to make the damages more than the usual, is it?
Much obliged to your lordship, yes.
Make it excessive, is it?
Much obliged to your
So
lordship.
you agree that they are excessive?
Yes, we agree that the damages were not excessive, but were within the right range, so that other
Don't say they're excessive.
the statement, or rather the way prepared as excessive, was advanced forth by the appellant, who argued that the grounds were, or who argued that the damages were excessive. Thus, we are countering that argument, saying that it wasn't excessive, it was within the range of the damages to be granted.
Do you believe there was a contumacious disregard of plaintiff's rights?
Pardon, Council 6, the question to be referred.
Do you believe that there was a contumacious disregard of the plaintiff's rights in this case?
Much obliged, your lordship. The rights of the plaintiff were not consummated. The rights of the plaintiff were held, or rather were not interrupted.
No, not.
Much obliged.
So that means disregard.
Council 6 did consult with
You only have 2 minutes. That means they were disregarded.
they were not disregarded.
So then there's no defamation. Why is it? If your rights are not disregarded, then everything is okay. Then why are you saying that there is no right is disregarded?
We are here as the respondents. I believe the question must be answered by the appellant who are advanced with you. Much obliged, your lordship. Council 6 that you rephrase the question for the last time.
Is there a disregard of plaintiff's rights?
In this case, the plaintiff's rights were not disregarded.
So there's no defamation. Because that's how punitive damages are given, and you agree with them. But you're saying they shouldn't be excessive, isn't it? They should be given, albeit not excessive. But then, if there is no disregard, then why pay?
We are advancing forth that the damages that were given were not excessive, but were within the right range, so that other publishing companies are deterred from continuing with the same vice.
So there was a disregard.
There wasn't a disregard.
Then why is there defamation? Punitive damages are given when there is oppressive behavior, aggravated behavior, or a disregard of the plaintiff's rights. And your assertion is that there is no disregard of the plaintiff's rights. So why are you saying that there is defamation if no right has been breached, if no loss has been encountered? Why is she even claiming?
Much obliged, your lordship. Council concedes.
Proceed, counsel.
Okay, so in continuing and
The same person.
okay, so having endeavored to prove this to this honorable court that the lower court was on firm ground when it indeed
You have proved, and we're the ones to
the statement is in having endeavored. Much obliged, your lordship. Having endeavored to prove to this honorable court that the lower court was on firm ground when it held that the statement were defamatory to the plaintiff, it is our prayer that the decision of the lower court and the damages that were granted be upheld. Much obliged.
I can say that just some general comments. Those are really dark ones. I like the fact that both sides are able to stand up and watch here. I think, to a very large extent, you all have very good articulation plans. You took your time, except in some instances where people became a little bit too fast. But you need to be able to be, your speech must be round, must be rounded when you're arguing. Before you cite an authority that is foreign, you need to ask for legal. And you must state that it is only of persuasive value and not binding, because foreign decision is not binding. They become binding when you have adopted them into our laws. I'm sure that's clear. When you're stating a case, cite it in full. State the court. State the cause number. That is very necessary. necessary. And ask if you must allude to the facts or you should go ahead with the principle. It is very pertinent that you follow side by side. Third, listen to everything the judge says. Everything. Every small thing. You will use that against the judge or for the judge. Because if I ask you one thing and you answer another thing, I'll just interpret that you're not listening to me. You're in your own world. Don't rush to consult. The fact that you're rushing to consult just means that you don't know. You're not sure. And so I'm asking you because I'm not sure. You need to have everything. Don't treat it as if I'm opposing you. What we're doing is reason. We reason together. Did it happen? Did it not happen? That is what we work with. And when you're doing your brief, everyone should know everyone's argument. Last time we had instances in the last session where a person is saying, this person was misguided. Your own teammate is misguided. Where were you when they were misguiding themselves? So everyone should know everyone's case, everyone's argument on the top of your head. Because you just don't have time to consult. Is this the case? Is it not the case? It's not everything that you consult. So you know someone's argument. When you're called to say it, you have to say it. Because judges can ask you a question that's at the end of a brief. That's our argument to you. Because we take it, everyone knows it. Once, that was very nice. But even we did that. We practiced that. That was very good.
I want to commend both teams. That was really nice. Honestly, to quote Daniel's words, I don't think any of us was that good when we started off. And you guys did an amazing job. I think the teams were equally fair, like they were opposing each other on the par, unlike the previous teams we had. So congratulations and all the best. I hope, not all of you can make it, some of you will make it. So well done. All the best.
Coach Rice. So we have another session. Another team is coming in. If you are still have time, please we require that you remain for the next session. For the panelists, you may kindly just join the podium as the other team. The court might be seated. Thank you.